Imagine a ruling that could dismantle decades of progress in ensuring fair representation for minority voters. That's the high-stakes showdown unfolding at the Supreme Court this week. In a decision that harks back to the turbulent days of civil rights battles, the conservative-led justices are set to debate whether to dismantle a pivotal element of the groundbreaking Voting Rights Act through a redistricting dispute originating from Louisiana. But here's where it gets controversial. Could this mean rolling back protections designed to prevent racial discrimination in elections? On Wednesday, the court will delve into arguments questioning if states can incorporate race as a factor when sketching out new congressional boundaries, all while striving to adhere to Section 2 of the 1965 Voting Rights Act. This landmark legislation emerged from a history rife with systemic racial injustice, aimed at safeguarding the voting rights of minority groups who had been systematically disenfranchised. To put it simply, Section 2 prohibits voting practices or procedures that discriminate against protected classes, including minorities based on race or ethnicity. Think of it like a shield against sneaky tactics that dilute the power of voters of color, such as drawing district lines in ways that split communities or weaken their collective voice. At the heart of this ongoing saga is Louisiana's congressional map, which the state had to revise last year following a lawsuit under the Voting Rights Act. The goal? To create 2 districts where black residents form a majority, up from just 1 in the original design. Louisiana boasts a black population that makes up about 1/3 of its total inhabitants, yet the initial map failed to reflect that demographic proportionally. This isn't just about numbers. It's about ensuring that voices long silenced by discrimination can truly be heard in the halls of power. Interestingly, the Supreme Court initially tackled this matter earlier in the year with a more focused lens on specific legal nuances. But in an unusual twist, during the summer, the justices broadened the inquiry, prompting the involved parties to revisit their arguments. They elevated the discussion to a fundamental constitutional question. Does crafting maps to guarantee majority black districts clash with the 14th and 15th Amendments? These post-Civil War additions to the Constitution were crafted to secure equal rights for formerly enslaved people, encompassing the crucial right to vote without undue barriers. Conservative viewpoints assert that these amendments demand a colorblind approach, ruling out any consideration of race whatsoever when designing electoral districts. This perspective aligns with the court's recent embrace of colorblindness, as seen in its 2023 decision halting the use of race in college admissions programs at institutions like Harvard and the University of North Carolina. It's a stance that prioritizes treating everyone identically, regardless of historical inequities. And this is the part most people miss. Critics of this view argue it ignores the persistent realities of discrimination that still affect voting access today. Curiously, Louisiana, which started by supporting its revised map, has now aligned with a coalition of voters identifying as non-African American, who are challenging it constitutionally. Even the Trump administration has thrown its weight behind this shift. Meanwhile, civil rights organizations that initially contested the old map are standing firm in defense of the new one, emphasizing the need for intentional measures to counteract past injustices. The Voting Rights Act has faced relentless conservative scrutiny, with the court chipping away at it through significant decisions in 2013 and 2021. Yet just 2 years ago, in a surprising turn, the justices upheld the necessity of factoring in race for redistricting when required by the law in a separate Alabama case. That 5-4 verdict saw 2 conservatives, Chief Justice John Roberts and Justice Brett Kavanaugh, side with the 3 liberals. Kavanaugh, however, voiced doubts about Section 2's enduring viability, hinting at potential future challenges. If the court rules broadly in Louisiana's favor, It could diminish the requirement for states to create districts predominantly comprised of minorities, potentially slashing the number of minority representatives in Congress and state legislatures. This shift might also have real-world ripple effects, such as reducing the influence of Democratic-leaning black voters and tilting the scales toward Republican gains. And here's a subtle counterpoint that might spark debate. Some argue that such changes promote true equality by focusing on individual merit over group identities. But others contend it risks erasing hard-won protections against voter suppression tactics, like gerrymandering, where district lines are manipulated to favor one party or group. A swift decision could allow Louisiana and similar states to finalize new maps before the 2026 midterm elections, influencing political outcomes in tangible ways. With black voters frequently supporting Democratic candidates, this could alter the balance of power across the nation. What do you think about all this? Is a colorblind approach the key to fair elections, or does it overlook the need for targeted remedies to historical wrongs? Should race ever play a role in redistricting, or is that a step backward? We'd love to hear your take. Agree, disagree, or offer a fresh perspective in the comments below. Let's keep the conversation going. Lawrence Hurley is a senior Supreme Court reporter for NBC News.